I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit.
You could stand up, sir, unless you're disabled.
Go ahead, stand up.
Oh, sure. Sorry, Judge. I told him to have a seat.
Aaron Flesher.
All right. And Mr. Westmoreland, your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Flesher.
All right. And Sergeant, your name?
Detective Sergeant Driscoll, Trent Police.
It looks like Judge Mullins, I believe I was absent that day, as I recall it. I don't know if you remember, Lisa, but I was absent, and Judge Mullen, my place, I think,
Yeah, you're correct.
set a 5,000, 10% bond and ordered him not to have any contact with Adam Grote, not to enter or go near 3750 Brookshire and Trent, no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs, no firearms, no dangerous weapons, and defendant was required to obtain a...
What you're about to see is not just a bond hearing. It's a slow, uncomfortable unraveling that happens in real time. This case starts out routine enough. A defendant who failed to comply with bond conditions, a GPS tether that was never obtained, and a judge simply trying to figure out what went wrong. But very quickly, this hearing takes a sharp turn into something far more serious. The defendant, Aaron Flesher, insists his life is in danger. He claims he's being followed, sabotaged, and targeted by forces far bigger than himself. He says he broke a secret code, exposed it back in 2008, and that everything happening to him now is the result of that decision. And instead of calming the situation, every answer he gives raises even more red flags. Watch how the judge's tone shifts, from procedural to skeptical to openly concerned. Pay attention to how the court tries to slow this down, protect the defendant's rights, and keep him from hurting his own case, while he continues to talk. This isn't courtroom drama for entertainment. This is the justice system trying to balance public safety, mental health concerns, and due process, all in one tense hearing.
Tether within 24 hours of release from custody. So, hang on one second. Yeah. I'm going to talk to you about fucking cheap marijuana. Well, I've been meaning to talk to you about that for 2 weeks. Okay, so then I got a signing on record on the, he was in Chattanooga, failed to acquire the GPS. Court found by preponderance of the evidence that the defendant violated his bond condition by failing to acquire a GPS. I revoked the release, forfeited a bond, and ordered $50,000 cash or surety. So, what are we going to do on this one, Mr. Westmoreland? I mean, I could take, you can just argue bond, or if you want to have a bond hearing as to whether or not he failed to acquire his GPS tether as ordered by Judge Mullins, that's fine too. What is your preference here?
Your Honor, I would just ask that this matter be reset, and I will argue bond on behalf of Mr. Flesher.
Sure, go ahead.
Your Honor, I would like you to know that Mr. Flesher is currently homeless, and he is currently unemployed, so he has no means of paying for any sort of tether. He's not currently on probation or parole. I don't believe he has any prior criminal history. At least he indicated to me he did not. He has no other pending matters out of any other court. And after speaking with Mr. Flesher at length this morning, he did assure me he would be appearing at all future court dates, and he does understand the importance of doing so. I believe last time he felt that he was threatened and he could not appear. But moving forward,
Wait a minute, say that again.
Mr. Flesher indicated to me that he felt that he was in grave danger and he could not appear.
Danger by who? From who?
Your Honor, I'm not exactly sure at this time, but Mr. Flesher did assure me he will appear and he understands the importance of doing so.
Did he make any police reports?
Not to my knowledge.
He's I don't know if Judge Mullins ever signed the complaint. I wonder if we can send that. Can you send that over to her? Oh, wait a minute. She signed the warrant. She did sign the complaint. Why did you leave without getting a GPS tether, sir?
I feel that
This moment is crucial to understanding why the judge is already frustrated before the defendant even starts speaking. The issue here isn't subtle or complicated. A GPS tether was ordered as a condition of release, and it never happened. That alone is enough to revoke bond. Courts take GPS monitoring seriously because it's often the only safeguard protecting alleged victims, witnesses, or the public. The judge isn't speculating, she's referencing a clear record. The defendant was released, failed to comply, left the state, and didn't resolve the tether requirement. That's not a misunderstanding, that's a violation. And when bond conditions are violated, the court doesn't need a dramatic explanation, it needs accountability. So when defense counsel asks to argue bond again, the burden is already high. This isn't a clean slate. The judge is now deciding whether the defendant can be trusted at all. And as you'll see, everything that comes next only makes that decision more complicated.
My life is in danger, and that's what set this whole thing in motion.
Your life
The
is in
mail-
danger.
I have no interest in defrauding Grow It, Adam, or
I want you to talk
anybody
about
else.
hang on. I
What, sir?
want you, hang on. I want you to talk about the case. You should not be talking about the case.
Okay.
I don't know why you're telling me your life was in danger. Did you tell Judge Mullins your life was in danger when she was setting the bond?
Yes, I've told everybody.
He tell you this, detective?
He did not, Judge. Me and Mr. Flesher has not had any real conversations to that effect.
You told Judge Mullins at the time of the arraignment that you felt your life was in danger? I don't want to put words in your mouth.
A tether tracks to exactly where I am.
Say that again?
The tether would track to exactly where I am. I was moving around to try to avoid. I have to give you the whole story, or you don't get the whole picture. Yes, my life is in danger, absolutely 100%, and I have documentation that proves it inside and out. That's why I'm more than happy to come to trial. I'm more than happy to speak to a judge and a real lawyer and everything else. I have no problem with that.
I'm a judge, and he's a real lawyer, and he's a real detective.
Okay.
Listen, Mr. Fleeser.
Here's where the hearing takes a sharp turn. The defense introduces the idea that Mr. Flesher didn't appear or comply because he feared for his life. That's not a minor claim, it's an extraordinary one. Judges hear excuses every day, but claims of imminent danger require evidence, documentation, police reports, something tangible. And right away, the court starts asking the right questions. Who is threatening you? Did you report it? Did you tell the judge at arraignment? Did law enforcement know? And the answers are vague at best. No reports, no names, no confirmation, just a general sense of danger. From a legal standpoint, that's a problem. Courts can't operate on feelings alone, especially when bond conditions are at stake. This is also where credibility starts slipping. When someone raises a serious claim only after consequences appear, judges get cautious. And that caution quickly turns into concern as the defendant begins explaining why he believes the tether itself would put him in danger.
You were ordered to get a GPS tether. I know not what you're talking about, sir. I do not know what you're talking about. Have you ever treated for mental illness, sir?
No, sir.
Do you work?
I haven't worked in a long time, sir.
How long?
I don't have a problem working. I'm not a bum. I have skills. I'm more than
You said you
capable.
were
My
a
phone
bum. How
calls are
long since you've worked?
Since. So you mean since I've been paid for work? Probably about April 2008, maybe.
Where do you live now?
I'm denied employment. My phone calls are intercepted.
Where do you
My
live now?
Visits to law offices are intercepted.
Listen to
Just
my
telling you,
question.
I want to be honest with you.
Well, I want you to be honest with me too. Where do you live now?
I go from hotel to hotel to hotel to outmaneuver whatever the heck it is that's coming after me. I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit. The code is basically how they get rid of people they don't care for.
The federal government you're talking about?
Correct.
Oh boy.
It's none of it's legal by any means, but it's very damning to say the least. So I kind of keep that to myself, but it doesn't allow me to survive. Like I said, I'm not choosing to have my calls intercepted. I'm not choosing to have my automobile sabotaged, my family's home sabotaged. The list goes on, and that's why I know you don't want to go into detail. But I have to be honest with you. Yes, my life is in danger. That is the whole reason why I'm here.
This explanation is where the courtroom tension spikes. The defendant claims the GPS tether would reveal his location and expose him to harm. On its face, that sounds paranoid, but the court doesn't immediately dismiss it. Instead, the judge listens, asks clarifying questions, and gives him space to explain. That's important. This isn't mockery, it's judicial patience. But the problem is the logic. GPS tethers don't broadcast locations to the public. They're monitored by authorities. And the defendant isn't describing a known threat. He's describing an unseen, unnamed force that seems to control everything around him. From a legal perspective, that's not a justification for noncompliance. It's a warning sign. At this point, the judge isn't just thinking about bond anymore. She's assessing whether the defendant understands reality well enough to comply with court orders at all. And the more he talks, the clearer it becomes that something deeper is going on.
Why I took the mail that I took.
All right, you should
Don't
not be
speak about
saying
the
that. You should not be saying that. You should not be saying that, sir. You just should not be saying that. I'm trying to
You want
caution you. Not listen to me,
why my life is in danger?
please listen.
Go ahead.
You shouldn't be making admissions. You should not be making statements that are against your interest. I'm concerned here. I don't know what to tell you. I'm going to set $2,000 cash or surety. $2,000 cash or surety that you're going to have to post. And this time, I'm going to change the bond conditions ever so slightly. You're not to have any contact with Adam Grote. You're not to have any contact with prosecution witnesses. You're not to enter or go near 3750 Brookshire in the city of Trenton. You're not to possess firearms. You're not to possess dangerous weapons. You're not to purchase, possess, or consume alcohol or illegal drugs. You're not to be released until fitted with a GPS tether. You're not to be released until fitted with a GPS tether. So even if you post the bond, you're not going to be released until they can fit you with a GPS tether. Also, I'm going to order you to attend a psychological evaluation and treatment. You can call the probation department. So if they recommend probation's going to give you some names as to where you can go. You're to attend a psychological evaluation and treatment if recommended. So those are the bond conditions. I'm adding a couple that Judge Mullins did not have. And you have never heard anything about this at all, Sergeant?
I have not, Judge. I know there was some conversation about his monies.
When the judge starts asking about work and housing, this isn't small talk, it's assessment. Stability matters in bond decisions. Employment, housing, routine, these are anchors that suggest someone can follow rules and appear in court. And here, every answer points in the opposite direction. He hasn't worked since 2008. He moves from hotel to hotel. He believes his communications are intercepted and law offices are monitoring him. These aren't just hardships, they're reinforcing a worldview where everyone is part of a threat. And notice how the judge keeps trying to pull him back to basics. Where do you live? How do you support yourself? The answers don't ground the case, they escalate it. And for the court, this raises a serious question. Is this person capable of complying with structured supervision, or does supervision itself feed the perceived danger?
Being funneled out of his bank account, but we didn't get into a conversation involving people coming after him.
All right, so Mr. Fleezer, I'm sorry. I'm gonna give you a new date. It's gonna be, what, January the 6th, is it? Lisa?
January 6th at 10 o'clock.
January the 6th of 2026 at 10 a.m. I hope you didn't pre-try that with those guys. I told them we needed an Arabic interpreter.
His son spoke for him.
Yeah, you can't do that. It's a criminal case. I just can't do
I
it.
understand.
I just can't do it. I tried to tell them that. I mean, it's a criminal case. I'm supposed to get an interpreter, so I can't. I'm sorry. I just can't do it. That's the way it is, Mr. Fleezer. I'm sorry. So I want you to get a psychological evaluation and treatment. You can post $2,000 and you're not going to be released until fitted with a GPS tether. Okay? Do you understand, sir?
Yes, but I don't have $2,000.
I'm sorry. You should have shown up. You should have shown up. You didn't get your tether and you left the state.
I was told that,
sir.
I was told that the actual
Sir.
judge wouldn't be there.
What's that?
I was told the actual judge wouldn't be there, that somebody would be sitting in who doesn't actually normally be there. Plus, the lady that I spoke to, that was the judge, had the same name as you, sir.
No, she did not have the same name as me. It was Judge Mullins.
It did on the screen when I talked to her, because I was wondering why it was McNally, because that was the paperwork posted on her house.
Okay, listen. You were in front of Judge Mullins. You were in front of Judge Mullins. She told you to get a GPS tether. You didn't. I'm not going to argue with you. You're going to have to post $2,000 and they'll give you a GPS tether. If you post the bond and you get the tether and you are released, I want you to get a psychological evaluation and treatment, okay? They don't need to come in here. I already told them to go down the home.
I know, Judge, you can speak English. Young.
No, Mr. Muhammad, come on. He told
Judge, we
me
all
he
set?
could just, yes.
Thank you,
He
Judge.
All right, thank you.
told me he could